Good afternoon. My lecture is basically divided into three parts. The first part is just a brief and basic talk on patents and patent portfolios. The second part introduces industry standards, and the third part talks a little bit about patent pools. Basically, a patent grants you the right to prevent others from making, using, or selling or importing the patented invention, but it doesn't give you the right to use your invention. If one of your competitors or someone else has a more basic invention that's patented, then you cannot use that person's patent without their permission. Now, few patents by themselves really are sufficient to give you commercial success. Now, there are some exceptions to that. Some pharmaceutical patents are very important commercially. But for most fields, most patents, one patent won't really make your company a success. So you need to have more than one. And basically, a patent portfolio is just a group of patents that are zoned by the same entity. Now, the most obvious question, I guess, is, well, which patents should you apply for? Which inventions should you try to have patented? And that's a very difficult question to answer quite often. One of the problems with applying for a lot of patents is that it's very expensive. In the United States, applying for a patent and maintaining it can cost $30,000, $40,000. And if you're going to have a family of patents, it can, international family of patents, it can easily cost $100,000 or more. So you need to be careful which patents you apply for. So you really need to, I guess, consider the business objectives of your company and some other things to make your decision as to which patents you're going to apply for. One of the things that you would consider is, do you intend to sell the service or product, or do you just want to seek licensing revenue? If you're going to sell the service or product, the patent portfolio should carve out an area of exclusivity, so that you have an area that you can prevent other people from practicing in. For example, a patent portfolio might cover reasonable alternatives to the best approach, even if you don't have any plan for actually marketing the best approach. And that way you can prevent competition, you can prevent other people from invading your niche. You might file patent applications for different aspects of the invention in case the broadest aspect of the invention isn't patentable. For example, you could have patent application relating to a system, but if you don't get that patented, and if you haven't applied for a patent relating to components of the system, you might have delayed your eventual patent, or you may lose your rights to parts of the invention. So you need, when you're applying, you need to figure out which parts of the invention you're going to apply for. And of course, licensing, even when you're applying at the application stage, it's helpful to consider, what licensing revenue what kind of a licensing revenue stream you may want. You don't need, if you're just looking for licensing revenue, you may not need to protect your own market. And you might seek areas where the invention is applicable. For example, if you have an invention directed to a kind of glue or something, you may want to look for where the markets that would use that glue, and then see what kind of licensing revenue you could get from that before you applied for the patent. Sometimes licensing is useful or necessary to participate in the market. Some industries, as you all know, they have open standards, but you may need to have some kind of a cross-licensing agreement to participate in the open standard. And patent owners might have influence over development of the standard, so you may want to have a patent so that you can kind of direct how the standard will develop. And of course, you know, sometimes open standards become closed, and it's good to have patents directed to the standard if that were to happen. If it's a non-open standard situation, you may have to grant licenses to patented technology to promote adoption of a standard. You might need to adjust royalties to attract participants if you do that. If you're charged with infringement, of course, cross-licensing might be used to ward off an attack, and cross-licensing may be helpful in gaining entry into a new technology area. And licensing can also be an additional source of revenue if your invention has uses outside of your industry. You can license those uses. When deciding what patent applications to file, you should consider future licensing issues to enable continued participation in the market and maximum royalties. Another question comes up is, you know, where to file? What countries are you going to file your patent application? Well, of course, you need to file where you're going to make use or sell the invention, but you also might want to file where your competitors manufacture the invention so that you can prevent them from doing that. Other considerations that are important when you're applying for a patent is you need to remember that patents can take a long time to obtain, and that technology might not be valuable after you've obtained your patent. So you might want to consider some other approaches. Also, you might want to consider trade secret. Now, there are advantages to having trade secret protection and significant disadvantages. A patent discloses how to make and use the invention and prohibits others from using the invention for a set term. The trade secret lasts indefinitely. But if a competitor discovers your trade secret independently, then they can use it. Not only can they use it, but they can patent it and prevent you from using it. And if, in the U.S. anyhow, if you've been using a trade secret to manufacture a product and you've been selling the product for more than a year, then you're prevented from patenting that. And if somebody else discovers it independently, then you're completely out of luck. Another consideration when you're applying for a patent is to make a determination of whether or not you'll be able to detect if other people are infringing your patent. If somebody is, if your patent is to a product, is to a process that makes a product, it might not be easy to determine exactly what process the person who's making the product is using. And if you can't detect infringement, then a patent may not be as valuable. Another consideration for patents, sometimes investors will just, rather than really look to the quality of the patents, they may just look to the number. So sometimes it might help just to have a large number of patents. Some practical considerations for considering when preparing patents is which country should you first file in. Usually it's easiest to prepare your application in your home country, and because the attorneys that are preparing the application, they have easier access to the inventors. And usually the attorneys speak the same language as the inventors, and the applicant usually will be more familiar with the local patent law in their country. For international filing, claim construction may vary widely by country. Quite often, our Asian clients will have the application translated to English for filing, and then have the U.S. attorney revise the application, especially the claims, and then use that revised application as a template for filing in other jurisdictions. And then usually they have their local attorney oversee the foreign filings. Now, let me talk a little bit about industry standards. An industry standard is a set of technical specifications that provides a common design for a product or process. And there are basically two kinds of industry standards. One kind is devoted to quality or safety issues, and basically it sets criteria by which products have to adhere to. For example, different fire codes will specify how long a door can be subject to fire, a certain temperature fire for a certain number of time before it burns through and so forth. But that's not really the kind of standard that we're interested here. I'll be talking more about compatibility standards, like programming interfaces. The standards during the early market of the videotape, there was the Beta, which was produced by Sony, and there was VHS. And the Beta, I think most people kind of thought was probably a better standard technically, but it won out. But VHS won out in the market, and so the market was what decided what the standard would be. And sometimes the government will dictate a standard. For example, in the early 50s and 60s, the U.S. government established telecommunication standards. But I think probably the most important standard or type of standard for our discussion here is those that are set by the private standard setting organizations, the SSOs. SSOs quite often are dominated by companies in the field, and they can have the potential to act as a cartel to block others from entering the field. SSOs can develop standards that are open or closed. If they're open, anybody can participate. If they're closed, you have to pay royalties. And there's also a hybrid standard, which is part open, part closed, and members agree to license to all on specified terms. Most SSOs permit members to own intellectual property rights relative to the standard, but most require members to divulge IPR, which they are aware. But policies vary very much among SSOs, and it's very important to determine exactly what the standards of the SSOs are, or the bylaws are, before a member of your organization becomes a member of the SSO. Most require IPR to be licensed on reasonable and non-discriminatory terms, at least to members of the group. And reasonable terms, including royalties, may be provided by the court. As I said, there's a large variation in SSO policies, and you must be careful when members of your company join an SSO. If you don't, you can lose your intellectual property rights. For example, if a member doesn't divulge patents as required by the bylaws, the patents might not be enforceable. Failure to disclose might cause an SSO to adopt a standard it might not have if it knew the standard was proprietary. So it kind of makes sense that if you're going to an SSO and you're pushing for a standard and you have intellectual property that the SSO doesn't know about, that it could be considered to be a fraud on the SSO. One example of that is Dell Computer Corporation versus the ITT. In 1992, the Video Electronics Standards Association adopted a computer interface standard for the VL bus for peripherals, and all members voted to adopt the new standard, including Dell. Members required to state that they did not own any patent rights covering the standard, and Dell made that statement. And then after the standard was adopted, Dell asserted a patent. And the FTC thought that Dell had used its competitors to help establish a standard so that it would be able to control the standard. Dell entered a consent decree with FTC not to enforce its patents. Even if it's not expressly in the bylaws, a court might find a duty to disclose based on, for example, industry practice. So if a certain industry has certain practices with regard to what's generally disclosed by its members, then the court may enforce that, even if it's not specifically written. Sometimes engineers will join an SSO without being aware that this could have great consequences on the company's intellectual property rights. So whenever somebody joins an SSO, I think it's important for somebody, an attorney or somebody else who's very expert in making such determinations, to review what the bylaws are of the SSO. Sometimes you can make representations to the public that might result in a loss of intellectual property rights. For example, if you're representing that the standard will be an open standard, and then later on you try to enforce your a patent, you may not be able to. If an SSO member breaches a duty to license, the court might order a license, or it might order payment of damages. And another important question about SSOs is, when can you withdraw? And if you do withdraw, can you enforce intellectual property rights that were developed during the time that you were a member? It quite often is not easy to terminate an agreement with an SSO. You might not be able to revoke a license for an existing standard. Patent rights or applications that existed while a member generally fall under any kind of a disclosure obligation that you had while you were a member. And of course, the SSO bylaws are contracts, but they're binding only on the members, so that non-members are free to operate however they want with their IPR. Let me talk a little bit about patent pools. A patent pool is an agreement between at least two patent owners to license one or more patents to each other or to third parties. And rights can be transferred to a joint venture set up to administer the patent pool. As far as I know, the first patent pool in the United States was in 1856, and it was directed to sewing machine patents. There were some issues involving standardization of sewing machines, and so a few of the major companies got together and they pooled their patents, and that was probably, I think, as far as I'm aware of, that was the only patent pool in the United States until around 1915, when there was another patent pool directed to airplane parts, and that was mainly because of World War I. I think President Franklin Roosevelt, when he was Secretary of the Navy, just after World War I, he insisted on, or he encouraged the formation of the patent pool for the aircraft parts. Probably the most important modern patent pool has to do with MPEG 2. The Justice Department in the United States kind of frowned upon patent pools because they considered it to be anti-competitive and against antitrust laws. And so there weren't a lot of patent pools that were that passed muster at the Justice Department until 1997, when the Justice Department was convinced to allow the MPEG-2 patent pool. And basically, the MPEG-2 patent pool includes most of the owners of the patents that would be infringed by practicing the MPEG-2 standard. And there was an administrative board, or administrative entity called MPEG-LA that was formed. It's a private entity. It was formed to pool these patents. MPEG-LA charges royalties to those who practice the standard, and the licensees pay royalties on how many units they produce, not on how many patents they use. So, for example, if you're infringing one patent, or the item that you're using is covered by only one patent, you would still pay the same to the pool as if you were using 10 or more patents. And the royalties to licensors are based on the number of patents each licensor has in the pool. So if Company A has 10 patents in the pool and Company B has 1 patent in the pool, then Company A would get 10 times as much royalties as Company B. And of course, that provides an incentive then for each person, each company that's in the pool to have multiple patents. And quite often what happens is that companies will apply for patents with very similar claims. And of course, not all owners of essential patents have to be in the pool. And in fact, the MPEG-2 pool, there are several companies that have patents that aren't in the pool. And now there are actually quite a few patent pools. Quite a few of them are administered by MPEG-LA, including the DVD standards, digital TV standard, and so on. And as I mentioned, there's a tension between antitrust law and patent pools, and the Justice Department and the FTC scrutinize patent pools. And they have a set of guidelines that it's a balancing act. There are some things that they look to see if there's a pro-competitive aspect, and factors they look to see if there are anti-competitive aspects. Pro-competitive factors include clearing of blocking positions, integration of complementary technologies, cost savings of avoiding litigation, reduction of transaction costs, whether there's a promotion of dissemination of technology, and the reduction of uncertainty in investment decisions. So the more of these factors that are present, the more likely it would be that the Justice Department and the FTC would allow a pool to be formed. Anti-competitive factors include: are firms excluded from effectively competing? Would pool participants collectively possess market power? And are the limitations on participation that aren't reasonably related to efficient development and exploitation of technology? Now, certain activities can render patents unenforceable, such as price fixing, royalty levels that drive competitors out of the market, price discrimination. Now, in patent pools, you need to be non-discriminatory in your royalties. Requiring royalties for patents that aren't necessary to practice the standard. But it's not always easy to determine which patents are necessary for practicing the standard. So if you have a reasonable belief that the patent is necessary, and it turns out later not to be, that wouldn't be considered to be engaging in anti-competitive conduct. And of course, hiding patent applications from industry standards committees would be considered anti-competitive conduct. And that's my presentation. So.
Generally, when they look at the committees look at patent pools, what are the sort of benchmarks they generally apply to test whether it is anti-competitive or whether it falls within the ambit of antitrust? Some examples, if you can just highlight as to what is the sort of test they apply to see whether a patent pool is anti-competitive.
Well, the main thing that they're looking for is whether or not the market would be advanced by having the patent pool. What are the advantages to allow the patent pool, as opposed to what are the disadvantages? Whether or not allowing the patent pool would result in less competition. Would it result in the market being more monopolistic? Now, to a certain degree, it would be okay to have a little bit of a monopolistic market if there were countervailing advantages, like if there are different entities that have patents that are blocking each other, so that no standard would, they can't agree on royalties and so forth, then it might be better to allow them, even if it is a little bit of a monopolistic market, it might be better to allow them all to have a patent pool and to at least there would be a standard. I don't know if I did.
Any other question?
Hello. Yeah. This is a general question related to US IP law. In India, we have a provision in the statute where proof of working of an invention in case of a patent which is in India has to be given to the patent office from time to time. Do you have a similar provision there, or is there a similar provision in the US law as well?
I'm sorry, I didn't
Statement of working of an invention. The patentee has to furnish proof that the patented invention is being worked upon in India. Is there a similar provision, or are there similar provisions? For example, if I have a patent in the US, do I have to furnish from time to time proof that I am using the patented invention in either US or any other country? Are there provisions in the statute?
I think the question is, do you have to use your patent?
Yeah,
yes, substantially less. Substantially less.
In the US?
Yes.
No, you don't have to use it.
Okay.
Any other question?
Sir, I would like to know, in US, for a joint venture, suppose if I have to transfer my right in favor of any joint venture, at the patent in favor of by creating a joint venture, what will the roughly stamp any charges are payable, or by design by creation of a joint venture automatically it can be stamp duty or something charges can be reduced, or any specific charge? What is the exact charges payable for this patent transfer in favor of a third JV?
I think, can you keep it a little clear and They're not audible here
It's
completely.
not audible.
Yeah.
Hello? Hello?
It's difficult to understand here.
Hello? Hello? Is it audible?
Oh, yeah.
Sir, I would like to know, suppose if a patent is to be transferred by creating a joint venture to a third joint venture company, so at that point of time, what will be the approximate charges payable in US?
I didn't understand completely the question. You say if there's a patent that's transferred to a joint venture?
Yes, joint venture, and then what are the standards and what are the working nature?
One company holding a patent and they're altogether creating a joint venture third company. So that company favor, this company is transferring its all IP, all patents in favor of the third joint venture company, they're transferring, as you also pointed in one of your slides. When they transfer these rights, patents in favor of the third party, third JV creation, what is the charges is payable by this
So charges
this third joint venture company in America?
in transfer of patents. Right? Charges, what are the
License fees.
paid?
Oh, well, the license fee can be whatever the parties agree to.
Oh, what is agreed by between the parties?
No, sir. What is is there any specific dollars that this many dollars you have to pay to the government of USA for this? For if you want to pay, per patent you have to pay this many dollars. Is that case, or else by statute, by design, by just mere creation of a joint venture, a third company, by merger, by way of merger or joint venture, automatically these patent rights or IPR rights can be automatically vested with a third party company? Can that in that way can it be done, or else
Like
a special fees are chargeable, payable by these companies?
Just
Those-
something like an assignment.
Yeah, transfer basically. It's a transfer we are discussing.
Yeah.
Your question is, what is the government fee for assigning a patent or a right in a patent?
True, sir. True.
Yeah. Okay. The government fee for recording an assignment in the patent office is $40.
$40 per patent.
Oh,
Per
yeah.
patent?
Always.
$40 per patent, yes.
Thank you, sir. Thank you.
You're welcome. I'm sorry I had a hard time understanding you.
Any other question? I think probably people are very overdosed. I think they would like to have a coffee, I think. And this too abstract topic, IPR itself. Anyhow, I think we have to thank Mr. Peter McKenna